And so why don't you give us a little bit of a rundown about exactly what the Fifth Circuit did find? Because, some of the poor analysis I've seen, not from any of the experts that I spoke to, but it's, in media, what I've seen is basically this idea that, well, domestic violence was not considered a societal problem in the same way that it is today back during the founding era. And so there weren't any laws at all that pertained really to domestic violence. And so therefore, Bruin's test says you can't have any gun restrictions based on domestic violence. But that's not really what the Fifth Circuit said, right? Their analysis was not that simplistic or kind of obtuse, right? They did a significantly more thorough job looking at this than that, right?
Yeah, I think to sort of keep it simple, the Fifth Circuit signed off on two longstanding prohibitions or bases for disarming Americans of their Second Amendment rights. The first kind of category of those that have been convicted or involved in the criminal justice system, including, potentially if you've been indicted but haven't been convicted yet, you could potentially be forced to give up your gun rights to get out on bail. So the Fifth Circuit laser focused and said, if obviously you're part of the criminal justice system, you've been convicted of a violent crime, you've been put in prison, any of these things, we have the right, the government has the authority to take away your right to bear arms, just the way we have the right to take away your liberty and put you in prison for life or to sentence you to death. So if you're convicted in the context of the criminal justice system, that is obviously perfectly fine. That is not any kind of a Second Amendment issue whatsoever. That's longstanding historical regulations to say if you misuse a firearm at the time of the founding to commit a rape, a robbery, or murder, guess what? Not only can they take away your gun rights away, they can take away your liberty and your life. So there's no debate about that. Then you have, on the other hand, the civil commitment stuff. Remember, one of the other aspects of 922G is if you've been committed through a process, if you've been involuntarily committed to a mental health facility, meaning, you have been deemed to be a danger to yourself or a danger to others, through a process which is often referred to, you kind of use as the Baker Act under Florida, but it's kind of referred to these Baker Acts, which basically is the process by which courts, after a robust hearing with experts, mental health professionals, lawyers, and the whole shebang, you've been deemed to be a danger to yourself or to others, and they put you in a mental health facility for treatment or whatever it is, then of course that basically is acceptable under longstanding, American law, and you can be disarmed there as well. In the same way, we can take away your liberty. What the Fifth Circuit said is when you look specifically at the Rahimi case, and here's something to understand about high-end lawyering. The old saying in higher-end lawyering is this, that a high-end lawyer is someone that can take things that are inextricably linked and de-link them in their mind and analyze them separately. So here, what the Fifth Circuit did is the following. They said, if you look at the timeline of Mr. Rahimi's situation, at the moment that he agreed to, without the benefit of counsel, mind you, when he agreed to the entry of this restraining order by a family court judge or civil judge down there in Texas, at that moment in time, he had not been convicted of any crime or anything like that. He may have been suspected of committing a crime, but he hadn't been convicted of anything. So the Fifth Circuit says, we're going to focus like good lawyers do and like good judges do at that moment in time where he has not been convicted of a crime. He's not been civilly committed as mentally ill. He is simply being subject to a ordinary domestic restraining order, which are handed out like candy in the the justice system every day, in virtually every divorce case, and every fight over children, and every fight over who owns the house. These things happen all the time, not to mention the red flag law, which this could potentially influence. What the Fifth Circuit said is at that moment in time, he had not been subject to any of this stuff. He simply says, I will enter. I will agree to the entry of this restraining order. And here's the thing, Stephen, this is really getting super geeky, but if you look carefully at the statutory language of 922G8 dealing with the restraining orders, and again, mind you, these are civil restraining orders. That's a very important word.
Right.
Civil restraining orders.
And that was a big point that the Fifth Circuit focused on, the civil
Exactly
aspect.
Right. Civil, with a lot less due process protections and the like than you would see in a criminal case, which is very, very robustly protected, obviously. But the thing is, under 922G8, there's two little subsections, either of which triggers a loss of your Second Amendment rights. One is that you are found by a court to be a threat to someone. You are literally found, like I've looked at all the evidence and I've concluded that you are indeed a threat to commit violence to yourself or to someone else, and therefore I'm going to restrain you based on the evidence in front of me. That's one aspect of that 922G8. But the other aspect is what the Texas civil court did. Now, what is that other part? It's an either or, it's disjunctive. The court in this restraining order decision, as I understand it, I haven't looked at it, but this is my understanding from what I've heard, my understanding of the facts. It said that all it said was that Mr. Rahimi is not allowed to go near his ex-girlfriend, and they're to remain apart. They're not allowed to harass each other. They're not allowed to beat each other up. They're not allowed to commit crimes or anything like that. And here's the thing. If you think about it, all that language says, Stephen, is it just reiterates the law as it exists right now without the benefit of a restraining order. I mean, I'm not allowed to go beat people up today. I'm not allowed to harass people today. I'm not allowed to stalk people today, right? I'm not allowed to hit somebody over the basement with a head with a baseball bat. I'm not subject to a restraining order, but I still am not allowed to do that. So the question is, if you have a restraining order, which was the case in Mr. Rahimi's situation, that literally does nothing more than says, stay away from each other and follow the law and don't hit each other over the head with bats and don't beat each other up and don't do any violence toward each other. What is that really saying specific to whether or not Mr. Rahimi himself is a danger to society? In many respects, it says nothing, because all it's really doing is reiterating the existing law of the land in the form of restraining order, because you're not allowed to do those things anyway, even if there's no restraining order. And the Fifth Circuit laser focused on this and said, look, there was never a finding that Mr. Rahimi was specifically dangerous. It was just a restraining order that says he's not allowed to go close to and, misbehave and do bad things to his ex-girlfriend, which he shouldn't, obviously, but he's not allowed to do it anyway, even if he had no restraining order. And that's what the Fifth Circuit says. Well, this doesn't really say anything. It doesn't answer the critical question that we think has to be answered under the Second Amendment is, at a minimum, is someone like Mr. Rahimi a danger to himself or to someone else, like you would have to find in the context of a criminal case or a mental health case for civil commitment? It does none of the above. It's just simply almost a rubber stamp proceeding, which happens every day in America just for the good of the order. And judges always enter these restraining orders because they don't want anything bad to happen, because if something bad happens, if they don't enter the restraining order and someone gets killed or something gets beat up, next thing they're going to be worried about is appearing on the cover of the newspaper as a judge that could have prevented the crime and didn't. And, judges don't like that. I hate to say it, because, they have careers too. And the last thing they want to be is blamed for allowing something like that to happen. As a consequence, the presumption is, if you deal with these judges, is to really rubber stamp restraining orders, because then they can't be blamed if something bad goes wrong, heaven forbid.